Hello everyone, Namaskaram. In this video, we are going to talk about the preamble of our constitution and we will read out the preamble of our constitution and the basic terminologies and terms related to it. Pardon me for some mistakes as it's going to be my first video. So, uh, preamble of our constitution, as we can read, it is we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economical, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution of India. Now, this was the preamble of our Constitution. The preamble of our Constitution of India is a brief introductory statement that sets out the guiding purpose, principles, and philosophy of the Constitution. Preamble gives an idea about the following. Number one, the sources of the Constitution, which is we the people of India. Number two is nature of Indian state, sovereign, socialist, secular, democratic, and republic. Objectives. Number third, which are objectives which we want to achieve through this constitution. Our main objectives are justice, liberty, equality, and fraternity. And the date of adoption, which is the fourth feature of our constitution, 26th November 1949. Preamble is all about three C's, that is country, citizen, and constituent assembly. In the first part, preamble states that people of India have resolved to constitute India into a sovereign, socialist, secular, democratic, and republic country. Secondly, the preamble has objective to secure justice, liberty, and equality to all the citizens of India and to promote fraternity among them all. Thirdly, it states that the Constitution is adopted, enacted, and given to ourselves by the people of India on 26th November 1949. Now we should come to the sources of preamble. The preamble is based on objective resolution drafted and moved by Pandit Jawaharlal Nehru on 13th December 1946 and it was adopted by the Constituent Assembly unanimously on 22nd January 1947. The idea of justice has been inspired by Russian Revolution 1917 and the ideals of liberty, equality and fraternity have been encouraged by French Revolution 1789. Preamble, whether a part of our constitution or not, we'll read about it. In Re Beruvari Union and Exchange of Enclaves, 1960, the Supreme Court held that the preamble is not a part of the Constitution. In Keshavanand Bharati versus the state of Kerala, AR 1973, the holy case we all know, Supreme Court rejected the earlier opinion and held that the preamble is a part of the Constitution. In LIC of India versus Consumer Education and Research Center, AIR 1995, Justice K. Ramaswamy said that preamble is an integral part of the Constitution. Now, the significance of preamble in the Constitution. In IC Golaknath versus State of Punjab, AI 1967, Justice Subbarao has stated that preamble contains in a nutshell its ideals and aspiration. The ideals and aspiration of our country, our nation, our constitution. Basic structure. In Keshwanand Bharati was the state of Kerala, AI 1973. It was held by the Supreme Court that the objective specified in the preamble contains basic structure of the constitution. The majority held that since the preamble is a part of the constitution, it can be amended but subject to the doctrine of basic structure, which was laid in this case, as we all know. And if you don't know, you should watch a video of Vikas Devagirti, Honorable Dr. Vikas Devagirti. Uh, if you will just search about that video, you will get the video. It's 2.5 hour long video, I guess. It's great video to develop an understanding. It's for the Hindi audience actually, but you will develop a better understanding by watching that video. Please do watch it. Sovereign. The term sovereign is used for an entity which is free from all external control and has absolute and uncontrolled power within its own spheres. The Parliament has sovereignty to legislate on matters provided in the Constitution in conformity with constitutional limitations. Recently, the United Nations High Commissioner for Human Rights, UNCHR, Michelle Bachelet, filed an application seeking to be appointed as amicus curiae, literally meaning the friend of the court, who is not a party to case and may or may not have been solicited by a party, and who assists a court by offering information, expertise, or insight that has bearing up on the issue in the case. In a case titled De Mukherjee and others versus the Union of India and others, writ petition of 2019, challenging the constitutionality of the Citizenship Amendment Act 2019, the CAA Act, if you know about it, in the Supreme Court of India. The Government of India, in a strong reaction, stated that CAA is an internal matter relating to the sovereign powers, right of Parliament to make laws, and no foreign body has any locus standi, capacity, or right to bring an action or to appear in a court on issues pertaining to India's sovereignty. If you remember the video of Amit Shah stating जान दे देंगे इसके लिए, it was about the CAA bill only in Jharkhand, sorry, in Jammu and Kashmir. The term socialist used in preamble connotes that India is a mixture of democracy and socialism where everyone has equal opportunity in economic, social, and political prospect. In Samantha versus the State of Andhra Pradesh, AI 1997, the Supreme Court, while defining socialism, has stated that establishment of the egalitarian social order through the rule of law is the basic structure of the constitution. The court laid emphasis on social justice as to attain substantial degree of social, economic, and political equality. The court to bring about the distribution of material resources of the country and to serve common good furthered the idea of distributive justice. Secular. The term secular states that India is neither anti-religion nor suggests separation of state and religion. It simply states that the state has no religion of its own. In Keshavan Bharati of the State of Kerala, A 1973, the Supreme Court held that secularism is the part of basic structure of the constitution. So even if amended, secularism will remain a part of the basic structure. So further, this was reiterated by Supreme Court in SR Bombay versus Union of India, year 1994. That secularism is a part of the basic structure. The term democratic indicates that the constitution has established a form of government which gets its authority from the will of the people. The rulers are elected by the people and are responsible to them. In the case of Mohanlal versus District Magistrate of Raebareli, in 1993, it was held by the Supreme Court that democracy is where the people elect their sorry for my fumbling. It was held by Supreme Court that democracy is where the people elect their representative to form a government and where the basic principle is to treat the minority in same way the majority is treated. Republic, the term republic enunciates that in India the executive head is not hereditary, rather he is elected indirectly for a fixed period of 5 years. So you can understand from the term republic again that in India, the executive head, that is either the president, prime minister, or any powerful position, is not hereditary. Rather, he is elected indirectly for a fixed period of 5 years. The term secularism, socialism, and integrity have been added in the Constitution by the 42nd Constitutional Amendment Act 1976 by the regime of Miss Indira Gandhi. Thank you.